Intellectual property. Patents. Patents protect intellectual property of product and process technologies that are new, non-obvious, and useful. Unlike copyright, patents are not automatic. If inventors invent new technology, they must apply quickly for the patents, or they will not get them. A patent is granted by a country's patent authority. If the new technology becomes publicly known, the patent authority will not grant the patent because, when the authority reviews the state of the art, it will find that the technology is already known. When a patent is granted, it is published. The patentee trades public disclosure of the technology for a monopoly over the use of that technology. Once the patent is published, anyone can learn that new technology, but they can only use it in that market of jurisdiction of the patent if they obtain the permission from the patentee. Every patent authority, an agency of a national government, grants patents only within its own jurisdiction. There is no such thing as an international patent. If the technology is already publicly known elsewhere in the world, whether it's patented or not elsewhere, the patent authority will not issue a patent again in that local jurisdiction because the technology is part of the state of the art, a global art. The world can thank the United States of America for the modern patent system. The American revolutionaries of the late 18th century believed that patents could stimulate innovation. They wrote a patent authority into the U.S. Constitution. The U.S. Patent and Trademark Office, known as the USPTO, built up in the 19th century, became the model for the rest of the world in the 20th century. The World Trade Organization's Agreement on Trade-Related Aspects of Intellectual Property Rights, or TRIPS, and the World Intellectual Property Organization, WIPO, have American roots. When the Communist Party of China's revolutionaries came to power in 1949, however, they had a different model of intellectual property. The Chinese copied the Union of Soviet Socialist Republics. They held Marxist views that the state of the art and its progress were public commons that should be available freely to all. Like the Russian Soviets, the Chinese encouraged workers and intellectuals to innovate, incentivizing them not with private intellectual property, but with prestige, privileges, and some pecuniary benefits. With the reform and opening up of the 1980s, China turned away from the Soviet IP model towards a Western IP model. In preparation for Chinese entry into the WTO in 2001, Chinese patent laws were aligned with TRIPS. Starting with the 10th five-year plan of 2001 to 2005, the CPC and the national and local governments of China actively encouraged patent filing. Today, the China National Intellectual Property Administration, SNIPA, China's patent authority, is one of the leading IP regulators in the world. China has two patent durations, 10 years and 20 years. The utility patent gives the patentees a 10-year monopoly over inventions in use-related product shape and/or structure. The design patent gives the patentee a 10-year monopoly over aesthetics-related innovation, that is, shape, design, color, etc. An invention patent, on the other hand, gives the patentee a 20-year monopoly. When people talk about a Chinese patent, comparing it with, say, an American patent, they're usually referring to the invention patents, the 20-year variety of patents, and the following numbers refer to invention patents. Patenting is expensive. Chinese filing fees are about $2,000 per patent. That's less than half the US filing fees, but filing fees themselves are not the main expense. A good patent that is to say, one that is likely to be approved by the patent authority and, more important, likely to stand up in a court of law, must be written by someone having knowledge of patent law, patent filing practice, the state of the art, and the technology of the innovation. Fees for these multi-talented professionals who help the patentee write and apply for the patent range from several thousand US dollars to well over $20,000 per patent, regardless of whether it's in the US, China, Europe, or elsewhere. Today, about 3 million invention patents are filed in the world each year. About half of those are filed in China. In terms of patent intensity, that is to say, patents filed per GDP dollar, China is the second most intensive filing patents country in the world, after South Korea. China is followed by Japan, Germany, Switzerland, and the US and Finland in that order. Although there is no international patent, there is an international option to file national patents. The WTO members subscribe to the Patent Cooperation Treaty, or PCT. PCT allows an inventor, with a single pre-filing prior to the actual patent filing, to reserve the right to file anywhere in the world within the next 30 months. The PCT pre-filing fee is relatively low, and it requires far less professional time to draft than an actual filing. Because of the expense and the difficulty of filing in multiple national jurisdictions, and because the inventor's understanding of the value of his own invention becomes clearer with the passage of time, this global option to delay, this PCT, is valuable. China leads the world in PCT filings. Huawei Technology of Shenzhen is the largest filer of PCTs in the world, with 2,661 applications, followed in order by Mitsubishi Electric of Japan, Samsung Electric of Korea, and Qualcomm of the US. These are 2019 numbers. Rules of the game change. Patenting is no exception. So far, China has followed the US lead in innovating the patenting system, whether it be encouraging individuals to enjoy patent rights of inventions made in government research labs, or in allowing limited manufacture of patented drugs by parties other than the patentee prior to the patent's expiry to facilitate tests of generic drugs. But the patenting system in force in the world today is highly flawed. Many patents that should not have been granted are granted. When they are litigated in law courts, whether that's in China or in the US or elsewhere, when they go to trial, they are found to be unenforceable. But the process of suit and countersuit, filing and counterfiling, to determine enforceability is time-consuming, taking 6 to 18 months in China and 18 to 42 months in the US. And it's expensive, costing US dollars 20,000 to US dollars 150,000 from filing the suit to the first court ruling in China. And that Chinese cost is far less than the US $1 million to $6 million in the US. So in China, like in the US, most lawsuits over patents are settled out of court. Companies are forced by competitive pressures to build ever-increasing patent portfolios. Huawei in China, like Google in the US, each has over 50,000 patents in force. Nobody could read and understand the complete patent portfolio. Both companies are expanding their portfolios, and that expansion is being copied by companies all over the world. If a company's competitors are filing trivial patents, the company tends to respond by filing trivial patents itself. Companies protect themselves not with single patents, but with thickets of patents, with forests of patents. So a tragedy is unfolding in the global patenting game. The winners are those who reap the legal and administrative expenses of the system. The deadweight costs restrict innovation. But so far, a viable, better alternative to the patenting system has yet to be developed anywhere.